Today we're going to talk about the difference between some of your powers of attorney and guardianships. So in Ohio, you can have two types of guardianship. You can have guardianship of the estate, which means someone is in charge of your money, all of your assets. And then you can have guardianship of the person, which means they're in charge of making medical decisions and basically care decisions for you. Sometimes you will have people that are appointed to both roles. Guardianships are administered through probate court. So if you want to start a guardianship, you're going to have to go down through to probate court and file an application. And then there will be a hearing to determine your suitability as a guardian and whether a guardianship even needs to be set up. And then for the duration of that guardianship, you will have annual reporting requirements and other types of reporting requirements that you will make back to that probate court. But the entire guardianship is administered under the jurisdiction and the supervision of the probate court. Now, a less intrusive way of taking care of a loved one would be your healthcare power of attorney and your financial durable power of attorney. So a financial durable power of attorney is a power of attorney that gives the power to the people named in the document to take care of your stuff. So they can take the power of attorney down to the bank. They can take money out of that bank and they can use that money to pay your bills. What they cannot do with a financial power of attorney is go to the bank, take money out, and send themselves on a world cruise. They can only use a financial power of attorney or any kind of power of attorney for your benefit. They have what we call a fiduciary duty, which means that they can only use it for your benefit, not their own benefit. So a financial power of attorney is going to give people the power to make decisions financially for you, take certain actions financially for you. It's a very, very powerful document. The other, and it would be similar to a guardianship of the estate, except the way it's set up is it's set up while the person is competent, meaning the principal. So maybe you're competent to say, I want this person to be in charge of my assets. So another kind of power of attorney that's very important is your healthcare power of attorney. This gives the power to the people named in the document to make healthcare decisions for you if you're unable to make or communicate your own healthcare decisions. They can also talk to your doctors, they can access your medical records, they can talk to insurance companies, talk to hospitals, things like that. This, like the financial power of attorney, is a document that's created while the principal is alive and legally competent to execute estate planning documents. So this would be very similar to the guardianship of the person, where they get to make decisions about where you're living, what healthcare you get, things like that. The big difference between these powers of attorney and the guardianship is that the guardianship is set up when the principal is legally incompetent, meaning they can't make their own decisions anymore, which is why they can't do a financial power of attorney, they can't do a healthcare power of attorney or a living will, because they don't have that legal competence to execute estate planning documents like that. So guardianship is normally going to be an option of last resort when you haven't done the planning to have the powers of attorney in place and it's too late to do that type of planning. There are other reasons why a guardianship might be chosen over powers of attorney, but those tend to be pretty case specific as to why there's that increased need for supervision. But definitely the most cost-effective way to make sure that you are protected in cases of incompetency is to, while you are competent, do those powers of attorney. Those powers of attorney, if they're properly drafted, will survive any incompetency, which means the powers of attorney can be used even if you no longer have the legal capacity to draft those documents. Another advantage of doing the powers of attorney over going the guardianship route is just finances. It's a couple $100s to do a power of attorney, but you're looking at, $1,500 to a couple thousand to do a guardianship. If it's contested, it can be something that is much more expensive and time consuming than a typical guardianship. So you can end up spending tens of thousands if you're talking about a contested guardianship. But if you are competent, it is better to do these powers of attorney so that no one's going to be paying several $1,000s to do a guardianship down the road. Also, by doing your own powers of attorney, you get to choose who is going to have these powers. If you wait until you're incompetent and you are now stuck in the position of having your loved ones having to seek a guardianship over you, you no longer have a say in who gets to have those powers. I have unfortunately seen a lot of fighting when it comes to guardianships. Family members are stressed out. They have sometimes extremely different ideas on what needs to be done for mom or dad. And so you can end up having a lot of fighting. You can also end up having people appointed that maybe don't handle things the way you would prefer. So be proactive, get those powers of attorney. It's going to be cheaper and it's going to satisfy more of your goals than waiting and being in a guardianship situation. Hi, this is Laura. If you like the video that you just watched, please feel free to subscribe or just hit the like button. You can also go to my website, which is lbesq.com. So that's LB as in Laura Blumensteel, ESQ as in I am a lawyer. You can go there and you'll see a lot of blog posts, and I try to have a lot of educational material up on my website. I update it regularly. So if you want to go over and get more information on any of the things that I've been talking about today, please feel free to check it out at lbesq.com. Thanks so much.